start and we'll get started. Hey guys, we're going to go ahead and get started. Now we've given a couple minutes for the stragglers to get in. So good afternoon. Lovely to see that we've got a really good crowd here. Today we've got the honor to introduce Attorney Josh Blackman here to the Federalist Society. Blackman is national thought leader on constitutional law and Supreme Court issues. He regularly advises federal and state lawmakers. He's been involved in several major constitutional law cases while also serving at South Texas as a professor and also being a scholar at the Cato Institute. Today, Josh is going to be giving his expertise on constitutional law with respect to the Insurrection Clause and its potential applicability to Donald Trump. So I'm going to keep my opening remarks brief, and without further ado, please give a warm welcome to Josh Blackman.
Thank you. It's a treat to be here back in Boston College. I always like to visit. You all saw the election last night, New Hampshire primary, right? Trump won. Haley, well, close to maybe thought, but she lost. And it looks like that Trump will be the nominee. No Republican can keep Donald Trump off the ballot, but the question is whether courts can keep Trump off the ballot. So my talk today is about Section 3 of the 14th Amendment, which you may have never heard of before this year. Most people haven't. You've always studied the 14th Amendment. There's due process, there's equal protection, there's the enforcement power, but then there's Section 3, which was passed in the wake of the Civil War. At a high level, what it does is that certain people are disqualified from holding certain offices. Again, this provision had no salience for about 150 years, but does now. And all began, of course, with our event about 3 years ago on January 6th of 2021. In the lead up to the election and thereafter, President Trump had a number of tweets. He urged people to say, come to Washington, D.C. We're going to have an event on January 6th. Why January 6th? That was the date on which the electoral votes are counted and certified in Congress. That's really the date the president's elected. It's not really when people vote in the ballot box, whatever. That's the key date that the election is certified by Congress. As we all know what happened that day, there was a huge incident at the Capitol. Maybe it was insurrection, maybe it was a riot. I'm not going to talk about that right now, but something happened. Immediately after that event, President Trump was impeached. The trial didn't actually happen until after he left office, but he was impeached probably before he left office. I hedge because it's not clear when the articles were delivered and when he actually left office. He was acquitted. And then in the wake of that acquittal, there was a question. Would President Trump be criminally charged in connection with January 6th? He eventually was, almost 2 years later. But the charge was based not on insurrection, but on something more boring, which was obstruction of official proceedings. Okay. Hello. We'll get the food. Thank you. After I finish speaking. Sorry. Yeah. So the charge is actually obstruction of official proceedings. Okay. To this date, no one has been charged with insurrection based on January 6th. Not one person. Instead, voters have taken to the courts. Voters have filed suits in states throughout the country, even in Massachusetts and elsewhere, arguing that President Trump is actually disqualified and they should not appear on the ballot. So far, only one court and one Secretary of State accepted that. The Colorado Supreme Court and the Secretary of State of Maine. Both of those bodies have ruled that Trump cannot be on the ballot based on Section 3. So I'm going to walk through this text. It's a mouthful. Let me just read it to you once. Thank you so much. It says, no person shall be a senator, representative, in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States, or under any state, who, having previously taken oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid and cover to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. I know it's hard to follow. Let me just break that down. And there really are 4 components. I've numbered them here. The first is, who does Section 3 apply to? It doesn't apply to anyone. It only applies to people who took an oath to the Constitution in certain capacities, as a member of Congress, as an officer of the United States, as a member of a state legislature, or as an executive officer of any state. So if you've never held any government position, Section 3 says nothing at all about you. You can't be disqualified. Number 2, what happens if you engage in insurrection, right? If a person took this oath, engaged in insurrection, there's a consequence. That's number 3. You cannot hold office as a senator, representative, elected president, VP, okay, of the United States. Again, if you've taken an oath and engaged in insurrection, you cannot become a Senate representative, presidential elector, or hold any office, civil, military, under the United States. The last part, number 4, is that Congress can remove this disability by 2/3 vote, which is a very high bar. It's the same bar to impose a constitutional amendment. Very high, very high. Why is this text so important? Well, Donald Trump is unique. Well, he's unique in a lot of regards. But in one regard, he's very unique in that he'd never held any government position before. He's the first president in American history to hold some prior government service, whether as a senator, or a member of Congress, or as a governor, or as a general, right? Every previous president held some government position, except for Trump. The first oath, really the only oath he ever took to the Constitution, was as president. Let's look at this language, right? In order for Trump to be covered by Section 3, he had to take an oath as an officer of the United States. As an officer of the United States. Right? Now, isn't president an officer of the United States? There's a second question. Let's say that Trump is covered by Section 3. Can a person who's disqualified become president? Well, if you notice, it lists a lot of positions here. Senate representatives, electors, but it doesn't mention the presidency. So the question, is the presidency an office, civil, military, under the United States? Is the presidency an office under the United States? If the presidency is not an office under the United States, then Trump can be president. Maybe he can't be a senator representative, but he can be president. This language matters. I don't want to put this in too sort of calm terms, but basically the outcome of the next election turns on whether the president is an officer of the United States and whether the presidency is an office under the United States. They might say, Josh, this is stupid. You're splitting hairs. Look, we have qualifications, and qualifications have to be strictly enforced. We have to be careful with our text. Trump can only be disqualified if he's an officer of the United States. That's it. Everyone agrees on that question, right? If the president is an officer of the United States, then Section 3 applies to Trump. If he's not, then Section 3 has no bearing, that all this litigation is for naught. Now, I come here as a professor. I'm also a lawyer, and I filed an amicus brief on this exact issue on behalf of Professor Seth Barrett-Tillman. Now, Professor Tillman's a law professor in Ireland. He's the world's foremost expert on this issue, and together we've written close to 1,000 pages over the years on this question. We've written many articles. I won't bore you with them. But since 2009 or so, Tillman's been arguing that the president is not an officer of the United States. So this is not a new position. It's not something he made up for Trump. This is something he's been arguing for a very long time. And I'll just give you a preview. The trial court in Colorado agreed with our arguments. The Trump lawyers have more or less adopted our arguments in their entirety. All the amicus briefs have cited us. So What I'm talking about here is really the basis for an entire branch of litigation which originated in our scholarship. So where do we start? Let's start with the text. All right. There are 4 provisions of the Constitution, 4, that use this phrase, officer of the United States. I'll look from one at a time. The first one you probably cite in common law, the Appointments Clause, right? It says, the president can nominate ambassadors, other public ministers, consuls, judges, Supreme Court, and all other officers of the United States. Okay? If you read that, the phrase all other officers of the United States suggests that these are all appointed positions, ambassadors, judges, ministers, and so on. And the president does the appointment. The president does not appoint himself. And some people say, well, Josh, isn't the president appointed by the electors? No, he's elected. If you look at the Constitution, it says the president is elected. It always uses the language of election and voting for the president, not appointments. People like to make this argument. They have to ignore a lot of text to get there. You have the Impeachment Clause. It says the president, vice president, and all civil officers of the United States shall be removed from impeachment, removed from office on impeachment. What's the significant there? The president and VP are listed separately from the civil officers of the United States. They're listed separately to suggest the president and VP are not officers of the United States. Someone says, wait a minute, Josh, I got it, civil. The president's a military officer. No, he's not. He's not. We're the civilian commander-in-chief. I give you case after case saying this. Hamilton said the president's civilian. The president's not a military officer, does not wear a uniform, not subject to the Uniform Code of Military Justice. He is a civilian in charge of the military. The Commissions Clause says the president shall commission all the officers of the United States. All. Good word, all. Does the president commission himself? No. Does he commission a successor? No. Some people said, well, wait a minute. The president does get a commission. When the joint session of Congress approves him, they say, here's the winner. We certify the results. That doesn't come from the president. It comes from Congress. So it's not a commission from the president. Then the Oath Clause. Article 6. If you held government service, you've taken an oath probably. It says the senators, representatives, and members of the several state legislatures, and all executive and judicial officers of the United States are required to be bound by oath for affirmation. The president does not take an oath under Article 6. He does not take an oath under Article 6. How do we know this? George Washington took his oath before the first oath statute was even passed. It was inaugurated before Congress even passed the statute, which makes sense because the president assigns statute to law. He does not rely on Congress's Article 6 oath power. Okay. George Washington took his oath on April 30th, 1789. The first oath statute was passed about a month later in June of 1789. Okay. The president takes an Article 2 oath. He does not take an Article 6 oath. So what does this show? In the Constitution of 1788, the best reading is the phrase officer of the United States refers to appointed positions. There's lots of arguments, people trying to throw sand in the air. The best argument is officer of the United States means appointed. But then we have a time gap, right? Constitution was in 1788, and the 14th Amendment was ratified. Then 80 years later, 1868. Did the meaning of officer of the United States drift? Did it move between 1788 and 1868? We have some evidence it doesn't. So George Washington Pascal wrote a very important treatise in 1868, and editions were published later. And Pascal said the Article 6 oath and Section 3 apply to the same class of officers. That is, the people who took an oath to the Constitution under Article 6 were those covered by the Section 3 clause. The president's not covered by either language. The president's not officer of the United States. This position was repeated throughout time. We recently found a newspaper from Louisville, Kentucky, not some sort of elite publication. Actually, Clark Louisville, I love Louisville. And it says very clearly the president's not officer of the United States, and the same evidence we do. The article was published in April of 1868, months before the 14th Amendment was ratified. We have the trial of William Belknap, Senator Booth saying the president's not an officer of the United States. He's part of the government. David McKnight wrote another treatise on election law. The president's not an officer of or under the United States. These statements were made. Modern executive branch opinions. William Rehnquist, I love the sideburns, right? When he was in the office of the legal counsel, The federal courts do not extend the phrase officer to the president unless there's a clear indication. Antonin Scalia, also at OLC, you gotta love the pipe, right? Says in the words officers used in the Constitution, it's referring to someone other than the president. All this is there in black and white. The Supreme Court has said many times the phrase officers of the United States refers to appointed positions over and over again. People don't want to talk about those precedents. Even in 2010, John Roberts said that people do not vote for the office of the United States. They don't. They're appointed. No one wants to talk about these cases. And look, even if there's a close case, right? We can construe office of the United States one way or the other. Let's favor the reading that promotes democracy, that promotes the right of people to vote. All right, so I've just laid out the case, which I think is actually pretty clear. And we've persuaded some people. So Steve Calabrese is a famous law professor from Northwestern, one of the founders of the Federal Society. He used to take the other position. Tillman flipped him. We flipped him. He changed his mind because of our scholarship. He actually said Tillman was right all these years. Good. Michael Mukasey in the Wall Street Journal, former Attorney General, has cited our position, but not everyone agrees with us. We're not well liked. It's because it's. I'll tell you why. The reason why people think our position is weird is because you didn't learn about this in law school, right? Any argument that's sort of new, it was like, wow, that's different. That's got to be weird. I didn't learn about this. It has to be wrong, right? It's a sort of this innate sense that if you don't know it, it can't be right. So people go out of their way to sort of attack it and to diminish it. They don't scrutinize the other side. Go cite checks in the briefs on the other side. You'll find some mistakes. But ours, we get the fine-tooth comb, as they say. So two good friends, Will Bode and Mike Paulson. I actually debated Will in Chicago last week. I had a very good debate with him. And Will says, a reading that renders the document a secret code loaded with hidden meanings discernible only by a select priest of Illuminati is an unlikely one. I'm an Illuminati priest, I suppose, right? The argument was, look, who knows about these officers? There's a secret code. No one's ever talked about it. Well, they did. They have to ignore a lot of stuff. Akil Marr, I don't know who he is. He's a law professor at Yale. Pretty famous. In his own mind, perhaps. He's famous, but in his mind, it's even bigger. He says, let me be clear. This is a genuinely stupid argument on the merits. I'm going to demolish it. It's embarrassing. This is very wrong. It's silly. It's so silly. I was laughing because I actually couldn't resist because even here, these formulations elicits laughter from me. Again, Akil does not acknowledge any of the contrary evidence. He just sort of writes what he wrote 30 years ago and then moves on. Another one is Mark Graber, who's a professor at the University of Maryland. He said our position is nonsense, it's mindless textualism, and so on. Again, they do not confront the various evidence. Now, I'll talk about the evidence they bring forward, and I'll address it. I'm going to be fair because I try to always be fair. So the first piece of evidence they cite is a report from 1866. It's called the Conkling Report. And the issue there is sort of not very important, but it's about whether a member of Congress was allowed to hold this other government position without a salary. I'm just summarizing it very grossly. But part of the issue, the committee had to decide about what does this language mean? Office under the United States. And the members of this committee reach a conclusion. They say there's no difference between office of the United States and office under the United States. It's used indiscriminately. And that's actually not a new position. They were actually quoting from the Blount impeachment trial. This was an impeachment trial from the late 1790s. And for sure, during the impeachment trial, some people said that these words used indiscriminately. But during the same impeachment trial, I can quote from Jared Ingersoll, who was a lawyer at the time. He said, these phrases are different. The Appointments Clause says the president shall appoint all officers holding under, the expression, the Appointments Clause is not the president shall appoint all offices under the United States, but officers of the United States. What I'm trying to get across is since the early republic, people looked at this language differently. Office under, officer of was viewed differently. For sure, Conkling Report adopted the view of Dallas. We think Ingersoll was correct here. All right. There's another piece of contrary evidence. So again, the argument that Tillman and I have an advantage is that the phrase officer of the United States. We're not arguing that under the United States. We're putting all of our eggs in this basket. We've not taken a position in this one. Okay. During the debates over the 14th Amendment, you had a question posed by Senator Reverdy Johnson of Maryland. He was a former attorney general. very well-known lawyer. And he says, wait a minute. You list all these positions, senators, representatives, electors. You don't list the president. Why did you omit the president? Johnson read this language the same way we did. They didn't mention the president. The president's not included. Reverdy Johnson did not think the presidency was an office under the United States. Maybe. And then you have another senator, Lot Merrill from Maryland, come in. Johnson was from Maine. Merrill's from Maine. Johnson was from Maryland, and Morrill's from Maine. I got that right. And then Morrill said, let me call attention to the words office under the United States. In other words, the president's covered by that phrase. And Johnson says, maybe I'm wrong. No doubt I am, but I was misled by the specific exclusion. Some people say, aha, this means that Johnson was wrong and Morrill was right. I don't read it necessarily that way. Johnson read it the way a person in the street would read it. And this debate was not widely reported at the time. So we think it's a reasonable reading that the president would not be covered by this phrase office under the United States under the expressio unius canon. Remember this from contracts, right? If you list a bunch of things and you omit one, that means the omission was intentional. They didn't include the president. And Professor Kurt Lash has made this point, I think, very vigorously, right? If Johnson, a prominent historian, was misled, then maybe the language didn't include that. We've not taken that position, but I think Kurt's made this position as best as he can. All right, so now where does this sort of leave us? The Supreme Court will hear argument on February 8th. So 2.5 weeks, pretty soon. The stakes of this case are quite high. If the Supreme Court affirms the Colorado Supreme Court, you might say, well, doesn't it end the case? Doesn't that knock Trump off the ballot only in one state? Right? Is Trump going to win Colorado? No. But you've heard of the doctrine called collateral estoppel. Remember this from Cipro? If Trump loses in the Colorado case, there's an argument that he's actually stopped from raising his defense in other states. So other states can knock him off the ballot. There's also the argument that under the supremacy clause, we've not made this, states will be required to take Trump off the ballot. If the Supreme Court says that Trump is constitutionally disqualified, could a state official let him on the ballot? So a ruling against Trump affirming across the board would take him off the ballot, probably in all 50 states, and would, you have Nikki Haley against, Biden, whatever would happen, who the hell knows, right? But the Supreme Court has many ways of resolving this. So the option we've given is a ruling on the merits. The idea is that if the president signed an offer to the United States, all this stuff finishes, goes away. No one can knock him off the ballot. Another option is the court holds that the presidency is not an office under the United States. In other words, Trump might be disqualified from being a senator, but he can become president. I think that's unlikely. There's some problems with that argument we've talked about in literature. I think the court's not going to go down that road. In fact, the Trump lawyers have more or less abandoned that argument. They haven't really raised it. They didn't quite forfeit it, but it's close to forfeiture. All right. What's another way they can rule? The court can say, well, there was no insurrection on January 6th. What is an insurrection? This is actually a very hard question. There's not a good definition. Go listen to the arguments in the Colorado Supreme Court. Neither side has a good definition of insurrection. And even worse, was January 6th an insurrection? That would mean you have to make very specific factual findings. You might have to adopt the January 6th report, which we all agree was kind of political. Right? This was done by Congress. Yeah, there were a couple people who were of the Republican Party at one point in the committee, but this was not a bipartisan committee that we can sort of just put our hats on. Maybe you say, well, maybe there was insurrection, maybe there's not, but Trump did not engage in insurrection. Right? In other words, he didn't engage. Well, whatever an insurrection is, Trump didn't engage in it. Well, that requires parsing Trump's tweets, looking at all the statements made at the Capitol, that's sort of the ellipse. This is a very hard position to muster. Another option is maybe this is a political question, or maybe the parties don't have standing, or maybe this should be belonging in federal court, not state court, right? The challenge with all those sort of off-ramps is that another state might come up in the right posture. right? Maybe in some other state the voters would have standing as a matter of state law. Maybe in some other cases brought in federal court, right? Let me give you one more thought. So the court can say Section 3 requires enforcement legislation, right? You need to have a statute to enforce it. We've argued this in our brief. We think it's a strong argument. But again, this sort of kicks the can down the road. And as you know, often when you punt the football, sometimes it gets returned for a touchdown, right? If you kick the can down the road, it might come back at you. So what happens if the court doesn't decide this on the merits now? The issue lingers. Trump will be on the ballot in some states. Maybe those states might take him off. This case will come back to the Supreme Court, who knows when. But everything comes to a head on January 6th of 2025 when the joint session of Congress meets. And what if there's a Democratic majority in both houses and Trump wins the election? Possible. Not like, yeah, it's possible. It could happen. Trump wins, but all the seats go blue. Can the Congress rule on January 6th that Trump is ineligible? Can they rule that the votes given to Trump are not given in a regular fashion? Not regularly given, that's the word in the statute. And can they select Joe Biden as president? Or maybe Nikki Haley becomes president? Either way, actually, as VP. Chaos. And then there's a question, who's the real president? Is it Biden? Is it Trump? Is it Haley? Is it Joe Manchin? Who the heck knows? So we write in our brief that, there are many ways that the court can resolve this case. But any off-ramp will just lead to chaos. So, we ask for a ruling on the merits. And we think the most likely, or actually the easiest, the cleanest way to resolve this issue is by holding the president as not an officer of the United States. There are mounds of precedent to support it. You can cite Joseph Story, you can cite John Marshall, you can cite all these cases from the 19th century. You can cite the text of the Constitution. All you have to do is get over this intuitive hump saying, this is crazy. How can that be the president's an officer? And I said, how can that be? If you just get over that hump, there's far more evidence on our side than the other side. Thank you so much, and I welcome your questions.
Yeah, so if the president isn't an officer of the United States, I think you made a pretty good argument for that.
Mm-hmm.
What would we call him in terms of applying laws to the office of the president? Would he then be an agency? Would he be some special position? What designation is he at that point?
Right. So one way of looking at it is the Constitution has different words, right? And one provision is called the Religious Test Clause. I skipped over. I'll come back to it. The Religious Test Clause, we have it here, right? So look at the Religious Test Clause. This is actually a very good starting point. It says the senators, representatives, blah, 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 and the officers of the United States without oath of affirmation, right? So the first paragraph is the oath clause, which speaks of officers of the United States. And the next paragraph says, but no religious test shall be required as a qualification for the office or public trust of the United States. And notice the same paragraph is different language. First one's officer of the United States. Second paragraph, office under the United States. And then there's this other phrase, this phrase public trust. Public trust, in our view, includes both the appointed and elected positions. So we would say the president holds public trust. And we think this position is not too controversial. If we're wrong about this, then why is the president immune from religious tests? We think the president fits under this phrase public trust. But let's be candid. The Constitution speaks of the office of the presidency. It does many times. But just because you're in office does not mean you're particularly an officer of the United States. It's specific language used in specific contexts. The way that people sort of pick apart our position, say, well, officer of, office under, who cares? The framers cared. They used very precise language in different paragraphs. They were very careful. If you actually look at the drafting history, this provision was modified. They changed this language to specific language, office or public trust under the United States. Precise language was used. They cared about it. Maybe we don't, but we probably should. Thank you for the question. Yes, ma'am.
Thank you so much. I don't have a question for now. I just want to invite people to go over and get food.
Oh, yeah, sure. If you want to go get some food, please. Yes.
Can
You getting your food?
No. I have a question in district.
That's all right. Yes.
Can you talk a little bit more about the collateral estoppel, what that would look like in terms of disposition and how that would be operationalized?
All right, yeah, this is a CIPRO question. It's not really a common law question, but I'll do the best that I can. There's a doctrine called offensive non-mutual collateral estoppel, right? And the idea is if you litigate an issue in one court and you lose, you are then as a party bound by the resolution of that case. So if the Supreme Court holds that Donald Trump is in fact disqualified in the Colorado case, he could not then argue in another state that he is not disqualified. So any litigation that arises in Massachusetts or Maine or whatever state you want, Trump will basically be stopped. He can't actually argue that he's qualified. And maybe there's some state law defenses you can raise that are different, but the bottom line is the federal question will be resolved against him. You would have every state court saying, well, it's a matter of estoppel. It's a default judgment basically. You can't. It's not exactly default, but you're stopped from arguing otherwise. The challenge, though, is that states do vary, and there might be some state-specific reasons why maybe Maine's different than Colorado. But at the bottom line, if the Supreme Court rules like this, Trump is done. You would basically have the Supreme Court ruling 50 states, Trump cannot be president. That makes sense? Yes, sir.
Is there another person in the entirety of state, local, or federal government that holds a position of public trust?
Members of Congress do as well. Yeah, we look at this phrase as office or public trust referring to everybody, right? Office under the United States is the appointed position in all three branches. Public trust refers to the elected members, representatives, senators, and the president and vice president. They all fit under this language. We don't think this refers to state positions. People said this means state positions. We don't think that matters. As a matter of modern doctrine, doesn't matter because the courts incorporated the exercise clause. So actually, this clause doesn't really much work anymore. But in the original design, it's only referred to federal positions. There were religious qualifications in states until the 1800s. Those existed for a long time. Yeah.
So you put up 4 provisions that talk about officers of the United States.
Yeah. I'll go back to that. 1 second. There.
And so for the second one, the impeachment clause, well, I guess it says president. So are we just assuming that the authority to impeach the president comes because he's specifically mentioned?
Exactly right.
Okay.
And this is not just an observation we had made. Joseph Story, you know about Joseph? He's from this state, right? From this Commonwealth. I lived in Kentucky, Virginia, and Pennsylvania. I lived in 3 of the 4, so you got the 4th Commonwealth. Joseph Story wrote, based on this text, that the president's not an officer of the United States. This was published in 1833, 120 years ago. Yeah. By listing them separately, you're distinguishing the president of the from the category of officers of the United States. Okay, let me go something new and I'll come back. Yes, over there, my Yankees friend.
If the Supreme Court does decide that he is this officer, does the court then need to answer the question as to whether or not there's an insurrection?
Exactly. Yeah, so our position is an off-ramp. If the court agrees with us, there's no need to decide there's an insurrection because the case is over. But if the court actually let me put it this way, put in sports terms. For Trump to lose, the other side has to run the table. They have to run about everything. For Trump to win, he has to run about one thing. But what's the one thing he has to be right about for the court? But yeah, for the court to rule against Trump, they have to go through every single hoop. He is an officer of the United States. He engaged in insurrection. He's covered by Section 3. Everything. There's a lot that's to go wrong for Trump to lose. I mean, it's possible.
All separate court cases on this case?
All in this case. Again, if the U.S. Supreme Court wants to knock Trump off the ballot now, which in some regards might be better than doing it later, they have to go through every single step. They can't do this piecemeal.
Could you speak a little bit about the difference between the Colorado Supreme Court taking them up and then the Maine Secretary of State and whether there's real
Yeah,
authority to do
Maine is a weird state. You probably know that it's an odd place. Under the provision, the Secretary of State is an elected Democrat. She's an elected position, and she has the unilateral power to remove someone from the ballot, subject to review in the state courts. So shortly after the Colorado Supreme Court ruled, the Maine court held a one-day hearing. That's just someone said before the hearing was inadequate in Colorado. That was 5 days. Here, Trump had 1 day. Almost no live witnesses were there. People were on Zoom. And the Maine Supreme Court said, yeah, what Colorado did, basically just Control C, Control V, right? Just sort of copied and pasted. And that is now on appeal to the Maine court system. The Maine Superior Court, I think that's what it's called, said, we're going to wait till the U.S. Supreme Court rules, don't get ahead of it. Now the Maine Secretary of State's appeal say, no, let's decide this now. Go to the Maine Supreme Court. I'm sure the Maine Supreme Court really wants to do this, right? That's exactly what's on their mind. But the big difference is who initiates it. But the legal questions are much the same. States have very elaborate mechanisms for ballot access, right? So imagine, you have to collect X thousand signatures from different people in different jurisdictions, right? States do this stuff all the time. It boggles my mind how a court 2,000 miles away from DC can decide, yes, it was insurrection, without interviewing anyone, without having a live testimony from the various people involved. Just there are due process issues as well. I don't think the court should rule on those grounds because it sort of just kicks the can, but the notion this be done by a trial judge in Denver or in Portland, Maine, is just strikes me as very difficult to sort of reconcile with how we think of due process generally. Yes, sir.
What's the strongest argument that you've heard on the other side? Like if you had to convince me to switch.
Sure. The strongest argument is the argument that there's no difference between an officer of the United States, right? This is just all stuff that's sort of made up. The idea is when the Constitution uses language, it's all synonymous. Akil Mar made this position almost 30 years ago in the law review. The other argument is that we shouldn't read the text so strictly. We should use what's called common understanding, right? How a reasonable person understands it. And of course, the president's an officer of the United States. What country is an officer of? Is he an officer of France? Is he an officer of Canada? Or is he an officer of the United States? There are some very complex arguments based on the appointments clause that actually maybe the president is appointed. It's hard to reconcile with how the Constitution says he's elected, but you could argue the president actually is appointed. You can say maybe the president does not have to commission himself, right? All doesn't mean all. You can say the president's actually a military officer, that's why he's not listed as civil. So the president does take an oath into Article 6, just Article 2 gives it precise wording. There are lots of arguments on the other side. I think the strongest one is the one that Will and Paulson say is, this is all nonsense. No one in 1868 said the president is not an officer of the United States in the Congress, right? No one actually made that statement. We have newspaper editors saying it, but no one in Congress said it. We think that's a very demanding standard. The other side has problems too. And let me just make this point bluntly. If it's really the case that the president's not an officer of the United States, all this language is, used interchangeably, there are consequences, right? One of which are members of Congress officers of the United States. Can members of Congress be impeached? The Conklin report, which I quoted before, seems to say yes, that members of Congress can be impeached. So perhaps tomorrow, if the Republican House wants to impeach Senator Schumer for Senator Elizabeth Warren to make it local, maybe they can. What is the Presidential Succession Act, right? Who's in line for presidency after the VP? It's the Speaker of the House. If the Speaker is not an officer of the United States, our succession statute is unconstitutional. It's not an officer, we have an unconstitutional succession law. That's chaotic. So there are consequences if you don't take this very seriously. We say, oh, whatever, potato, potato, the language is interchangeably. We try to be very careful. Yes?
I think you may have touched on this in the last answer, but I'm sort of struggling with, as a non-constitutional law person, with a methodological question. And that is, if some concept of originalism says, look at what the founders thought at the time they were adopting the language, and you put it in the context of Article 14, then you would say, look at the time that you've been discussing 1860s. How does that interact with textualism? In other words, so two questions or thoughts. You've been interpreting the document as a whole as a single text. And the question is, in the constitutional context, and particularly with the loss of originalism, should you look at Article 14 as distinct and even entertain the possibility that the same word has different meanings at different times?
Good question. Very good question. So there's a concept called linguistic drift. You read this phrase? What does linguistic drift mean? Let's say you have a statute uses a word in the year 1900, and then you have a statute in the year 2000 uses the same word. Meaning doesn't always stay the same. So, use an example, domestic violence is used in the Constitution to refer to, riots. So if domestic violence today, it means spousal abuse. right? So you're exactly right. Words can shift meaning. But we also know that the 13th and 14th Amendments were not written on a blank slate. They used language from earlier constitutions, and that was, we think, deliberate. So the 13th Amendment eliminated slavery, right? And if you look at the language in the 13th Amendment, it's very similar to the Northwest Ordinance. This is a law passed in 1788 or 89, which banned slavery in the Northwest Territories. The Due Process Clause is taken almost verbatim from the Fifth Amendment Due Process Clause, right? The Privileges or Immunities Clause of the 14th Amendment is very similar to the Article 4 Privileges and Immunities Clause. The framers were not writing on a blank slate. When they use language in the 14th Amendment that echoes what's in Article 6 Oath Clause, presumptions they use the same meaning. And I'm not making this up. George Washington Pascal wrote his treatise in 1868 that the positions in Article 6 and positions in Section 3 are the same. So you're exactly right. Maybe the meaning shifted. We need evidence of that shift. Everyone who actually talked about this issue said the meaning was consistent. No one thought otherwise. Yeah, the back.
Well, I think the court already obviously agreed here, but this is obviously the most controversial election-related cases since Bush v. Gore.
Yes.
Do you think, I find your argument in the office very persuasive, but do you think the court would make maybe a special exception, just like prevent it from, like what you said, further consequences that the ruling might have, just not just the ballot for Trump?
Right. So I got the question you can hear. This is the most controversial case since Bush v. Gore, and maybe the court might make an exception to the sort of this textual argument. Let me say this a couple ways. No matter which way the court rules, it's screwed, right? There are only dead ends here. If the court actually goes to full Monty, the whole 9 yards, and takes Trump off the ballot, that will be a stunning ruling that I think would reverberate. And I don't know that people take that one sitting down, right? I'm not sure what happens. If the court does anything short of that and keeps Trump on the ballot, people will still be angry, saying, how dare we have an insurrectionist in the White House, right? If the court holds that the 14th Amendment requires enforcement legislation, the court has to deal with a lot of cases which maybe suggest that the 14th Amendment doesn't require legislation like this. They have to reconcile cases. If the court holds that this is a political question, well, there's a lot of election cases, and those are not political questions. If, Barack Obama is not a natural-born citizen, or Ted Cruz was born in Canada, right? We have these cases every single election cycle, right? How does the court sort of, assuming the court says Trump stays in the ballot, how do they get there with the least amount of collateral damage or collateral estoppel, use a phrase? And we humbly submit that our approach is the cleanest way. It's consistent with the cases, it's consistent with the text. All you have to get over the fact is that people saying, oh, this can't be right. Once you just get over that hump, it's an easy opinion to write. The trial court in Colorado, again, this is not a Harvard law graduate, she's a respectable judge, wrote this in 5 pages. It's very easy to write. Cite those 4 clauses and move on, and let people vote for the president. But if they go down those other paths, they decide that Trump did engage in insurrection, that is a hard opinion to write. I mean, you have to go through the tweets, and then you have to decide what the tweets actually mean, and how much time elapsed between this tweet and that tweet, and when did Trump say go home, and did he say peaceful or fight like hell? Oh man, I can't imagine they want to do it. They don't do any of this stuff, but that's especially a hard opinion to write. Yes.
So Article 2 has a commander-in-chief clause.
Yes.
And the commander-in-chief, the way that I've sort of seen people in the military interact with the president, right? When he gets on a helicopter, they salute him. When he gets off the helicopter, they salute him. They refer to him as sir. Essentially, he's treated as the most senior officer in the military. So how does that not make him an officer?
Oh, he's an officer, but not a military officer, right? He's a civilian and head of our military. In some countries, you have actually a military head of state, right? You see this around the world. Here we have a civilian head of state. The president's an officer, no question, but he's not specifically an officer of the United States. This language refers to appointed positions. Are you in the service? You got the right, you have the right kind of haircut, right? Did you get a commission at some point?
I did.
Signed by the president?
Yes.
Yes, sir. Did the president get one of those commissions?
No.
No, he did not. He's not an officer of the United States. So he's an officer, but not an officer of the United States.
So is he of the United States, not the officer?
Exactly. The phrase is officer of the United States. That's the key phrase. The Constitution says the president's office. It says that. I'm not going to dispute that. But the precise phrase officer of the United States is defined by the Appointments Clause. 1 and 2, yeah.
So obviously, this is a politically loaded issue, and the court is going to want to try and deal with it in the least controversial way possible. What do you think are the odds of like a unanimous opinion either way, or per curiam or anything?
Yeah, I think it's be fractured as hell,
Okay.
right? So our friend brought Bush v. Gore a couple minutes ago. Bush v. Gore had 4 separate dissents, as I recall, and the majority opinion was somewhat all over the place. I think that's my recollection is right. When the court moves quickly, it doesn't do its job very well. Youngstown, you also the Youngstown Sheet and Tube Company, had like 6 opinions, right? And in fact, Justice Ginsburg later regretted saying he wished he had more unanimity of the dissenters, that we all spoke with one voice. But it's hard when you're writing under press deadlines. The Supreme Court is arguing on February 8th. Super Tuesday is what, March 10th, March 12th? March 5th. Thank you. I was off by a week. Yeah, March 5th. So I mean, like, look, they got to resolve this thing before Colorado has a primary. Primary is Super Tuesday coming up. So they have like a month, which is better than Bush v. Gore. Bush v. Gore than a couple days. But your question, sir, I think it's unlikely we get a lovely unanimous. I would love a 9-0 opinion by Justice Kagan saying the president's on office in the United States. That would just be like, that would make my day. It'd make Keelmar's head explode, right? I think it's probably unlikely. But whatever we get, it might be fractured. Maybe a couple of justices take the officer argument, a couple of justices say you need federal enforcement legislation. Maybe Justice Thomas says there was no insurrection, right? You know, I think you might get mix and match. You count to 5. Now, do any of the progressive justices go all the way and actually say, Trump, you got to be kicked off the ballot? Now, just be very clear. Let's say, I don't know, let's say Justice Jackson and Justice Sotomayor, just, you know, making it up, right? Decide that Trump is disqualified. They can just say, we affirm for the reasons stated by the Colorado Supreme Court. Make that 1 sentence. I guess they can do that. But anything short of that, they'd have to actually do their own analysis. And that's a long opinion. That's like over maybe 200 pages to actually do it for real. And, you know, do they want to write that opinion in a couple weeks? Maybe, maybe not. Maybe, you know, I haven't mentioned this, but Sotomayor and Jackson might be partial to a criminal law defense saying, well, you know what, whether it was insurrection or not, Trump didn't engage in it because he didn't go there. But those district court judges, they understand what criminal mens rea is. Trump did not have the mens rea to engage in insurrection. Maybe they'll say, First Amendment, Brandenburg, right? That Trump has a right to stir up the crowd, but he wasn't actually inciting violence as a First Amendment defense. Look, I can see 5 or 6 different opinions go different ways to get Trump safe in the ballot. That's fine. I'm not gonna cry over that one. But I just to see 5 justices affirming the Colorado court across the board, I just have a really deep, hard time thinking that's possible. So fractured is not bad. Maybe a tick good for one ride is really the appropriate issue in this case. But yeah, 9-0 opinion from Kagan. That'd be fun. Yes, sir.
Yeah, I think most of the sort of counter arguments to your position you addressed here, but one that I've seen thrown around a good few times refers to the Trump post office case in 2020, where the Third Circuit says that Trump used the the federal officer removal statute in order to remove it, which refers to officers and agencies. So would the court have to rule that the president's an agency to let that court?
You guys are so smart. Yeah, I love law students. You guys are so smart. All right, so let me make this point generally. There's something called a federal officer removal statute. If you sue certain types of federal officers in state court, you can then remove it to federal court. Okay? The reason why is you don't want state officials being punished by unfair state courts. And the statute uses the phrase officer of the United States. So when Trump was sued as president, he removed the case, suggesting the president's an officer of the United States. Ironically, after Trump was indicted in New York City by the district attorney, he also tried to remove the case to federal court, saying that as president, he was officer of the United States. At the time, we made a very loud thing saying, don't do this because this will screw up your Section 3 case, but no one listens to us, like Cassandra. There are lots of statutes. Lots of statutes use the phrase office, officer of the United States, and so on. We've never taken the position that our position is universal, that affects every statute in the U.S. Code. There's no obligation of Congress to adopt constitutional meaning in a statute. right? Again, there are lots of statutes we can point to which show the president might be an officer of the United States. That's not dispositive. What we would say, though, is that if the court wants to sort of go back in its own cases, it would have to say this, that when the court rules the president is an officer of the United States is appointed, that is a meaning for the Constitution, not for all statutes. They can make that clarification. But yeah, Trump's lawyers have not done him any favors there, especially in the criminal removal case. All right, what other questions we got? Anything else? We've been a very good audience. Thank you so much. I appreciate your questions. And enjoy the Chipotle. Thank you so much.